Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This video is exclusively for the professional ethics students. Friends, in the last three videos, section 29, 30 and 33, we have been discussing that advocates are only the class of persons. Advocates have got the right to practice and only advocate can practice. But now, we are deviating from the quite converse or quite contra in section 32. Section 32 says, the court has got power to permit appearance of anybody in a particular case. So you please remember the word appearance. Appearance is not equal to practice. This, if you remember this, it is sufficient. So the court can allow anybody to appear before. That's why legal representatives, GPA holders, all these people will come into the picture only with this section. Friends, all of you know that a person can defend himself. A person can defend without any advocate also. Yes, the court will allow a person if he wants to defend his own case. No problem. A lawyer cannot defend his relative's case, particularly near relative's case you cannot defend. If you know these points, it will be easy for you. So basically, according to section 32, please remember, any court may permit any person. Any court may permit any person, even though not enrolled persons, to appear before it. So actually, while discussing the free legal aid under Article 39A of the Constitution of India and even Rule 46 of the Free Legal Aid, or for that matter Section 7IB of the Bar Council of India rules functions, I told you regarding the free legal aid. So let us forget, put it as a point. Now whether the court can allow any person or not. Definitely court can allow any person. Even while discussing the CPC class, I told you that the court may allow the presence of even a common man who is conversant with the facts of the case. I gave the examples of that Annambhatla case. When the lawyer is funking, when that Chennupati Venkateswara was saying OS number, IA number, AS number, then the judge asked him, oh, you come, you tell. Yes, he has assisted the so-called case very well. A court can allow anybody. Right? With this brief introduction, I am sure that you are aware that the court may permit the appearance. Please remember, not practice, appearance. Very recently, a case has come. S. Ramachandra Rao versus V. Nagabhushna Rao. S. Ramachandra Rao versus Nagabhushna Rao, 2022. Right? So, S. Ramachandra Rao, so he has given GPA to his wife and he went to other country. He is staying in foreign country. So the wife appeared as GPA on behalf of Mr. Ramachandra Rao. This is a case, actually, okay, it's a civil case against almost relatives in Vijayawada it happened. Right? While appearing as GPA, she thought, why don't I study law? So she has admitted herself to law college, she completed graduation and she enrolled herself as a member of the Bar Association. Now, please remember, she is only a GPA holder in this particular case. Now she wanted to argue, because I became an advocate, yes, I have got all the right to argue the case. But already I told you, you cannot appear on behalf of your relatives. But she said, in the meaning of the law, in view of the law, husband is equal to wife, wife is equal to husband. But still, the court stated that, no doubt, she can be only GPA holder, but she is not an advocate and she cannot act as an advocate. This much you have to know. Like a very famous case, this is R.K. Chavala versus Goa Antibiotics and Pharmaceuticals Private Limited, 2005. The young executive, he was actually supporting the advocate on record in the court, but the advocate is not able to grasp the so-called pharmaceuticals or medical words. And this man wanted to represent the matter. Please remember, the court held that if a person is a non-advocate, he can appear only if after taking permission from the court. He cannot barge in the court. He cannot say, no, I will argue. No, it's not correct. You have to take permission. Then only you have to appear. The court can ask the person on what basis he is appearing to tell them, to clear the air on regarding the pharmaceutical or antibiotics name. Yes, court has to permit him. Otherwise you can't say, Your Honor, I will come and argue. No, it will not accept. Likewise, in case of C.Mathai versus Dist&Sessions Judge Trivandrum, 1999. Right. So, C.Mathai, he is the GPA holder in actually this marital dispute. In the case of a couple, right? Mathai sought permission to appear before the court and plead for it. Appear is okay, and he wanted to plead for the same. But High Court of Kerala did not agree. They have dismissed his petition. So, because Section 2 of the Power of Attorney Act cannot hold true to the general provision. He can appear, but he cannot defend or he cannot practice. Right? Lakshmi Suri versus Union of India and others, 2010. GPA holder can appear and plead in the court also. This is judgment. Yes, definitely court will be giving different. That's why I have put it in the last last example. Anyway, first 3 examples will be 100% satisfiable to you. Of course, sometimes the court may allow the other person to argue, right? So anyway, this is all regarding section 32. So by now you are clear that advocates right to practice. Okay, then the court can permit even a non-advocate also. Okay, with this I am concluding. Thank you very much.